Now, today we are going to talk about fire injury cases and specifically those cases involving personal injury or death. There are fire cases that are viable cases to bring where there may be commercial fires and a commercial property suffers a fire and sometimes property damage. Actually, a colleague of ours, a defense lawyer, handled a big case near and dear to me where it was a big warehouse down south that housed Porsches, a huge, expensive Porsche collection. And there was a fire, and tragically, a lot of these one-off cars were destroyed. So those are certainly cases, but those are not what we're going to talk about today. Today, what we're going to talk about is how to successfully litigate those cases where there is a fire in a residential premise where it's usually either a home or an apartment building, and that fire results in serious injury or death of the occupant. So those are the ones that primarily are what we as trial lawyers are going to see on the plaintiff side or defense side. And again, we are the New York State Academy of Trial Lawyers, so I'm focusing on New York State law. However, I know that there are people attending today's CLE who are practicing in other states, as well as people listening on the podcast from other parts of the country and world. So what you're going to want to do in a fire injury case is certainly look at the applicable statutes, laws, by common law, by printed law that are codified in your area. And we're going to talk about those laws specifically in New York and in New York City. And I will touch on some federal statutes as well that address this. But it will be primarily state-based and municipal-based, and we'll talk about that today. So again, usually there will be a consultation coming in if you're a plaintiff's lawyer or if you're defending a carrier where there has been a fire and someone has been tragically injured or dies in that fire. And today we're going to talk about the law that applies, the fact patterns we usually see, whether these cases are good cases, bad cases. I think some of you will definitely be surprised at what you may have previously thought was not a good case. That can actually be quite a good case. And the fact pattern I'm going to share with you today of one of my cases will reflect that. Let's see. So injuries are usually bad in fire cases. You're going to see an injured party that has usually severe burns. Usually, if they survive, there's going to be brain injury from carbon monoxide, from some asphyxiation, from inhalation, lung injuries. They're really usually very horrific injuries. And of course, the burns that can be sustained in these fires can go on the face, the body, and really have devastating consequences. If people are not able to survive these fires and they die, there's often a claim of conscious pain and suffering before they die, if you can prove it, and we'll talk about that. Sometimes it's at the scene. Sometimes they survive for months in a hospital or in a burn unit, and then they pass away. So these are very heavy damages cases. So they're going to need the proportional workup, whether you are on the plaintiff side or on the defense side, because the exposure and potential recoverable damages in these cases are usually quite large. And in fact, you're probably not going to want to undertake one of these cases unless it looks like there is a significant injury or death, because the time that will be required and perhaps investment of monies and energy in these cases can be very extensive and expensive. So today the goal is to give you this overview so that when one of these cases may come across your desk or phone or email box, you will have an idea of sizing it up. And if you take it on, you know what to do. All right. So what are we generally looking for when we are faced with the potential litigation of a fire case that results in injury or death? Well, First of all, you're always going to want to find out what the cause was. Why was there a fire? And generally, you'll find a couple of ways that fires will occur in homes or in apartment buildings. They'll usually be an electrical fire. It'll be sometimes, problems with the wiring in the building, in the structure, and that can cause a fire. Sometimes the residents themselves will often be the cause of the fire. They either leave something burning in the oven, on the stovetop, cigarette smoking, candles. More often than not, it is usually the tenant or resident of the apartment or home who causes the fire. All right. Now, you're going to want to look at what was the cause. Is there a viable defendant? Before you even get into what would you have to prove, and we're going to get into that. You're also going to want to find out immediately whether there were smoke alarms and carbon monoxide detectors. The laws in New York State and New York City and across the country are currently that residences are required to have smoke alarms and carbon monoxide detectors. In the data and studies, there's a lot of information out there, all show that if you have a properly placed and properly working smoke alarm and combination smoke alarm, carbon monoxide detector, and or a separate smoke alarm and a separate carbon monoxide detector, that they are effective. They are effective for early notification of a fire. Usually these alarms will go off before there's even significant flames. And that's the key. They give you enough notice that there is a fire to either put it out, or if it's going to be too hard to put out yourself, or get the fire department in to at least get the hell out of there, and then call for help. So at least you're not suffering an injury or be exposed to the potential for death. And we're going to talk about the significance of smoke alarms, carbon monoxide detectors, the laws, and all of that. Right? You're also going to look at whether or not there was a safe means to escape the fire. Okay. So that's called egress. Egress is going out, ingress is going in. So you always want to make sure that there's a safe means of egress. Fire could start, an alarm could sound, but you can't get out. Okay. Maybe you're in a basement apartment and the fire is separating you from the staircase up. That's a problem. So you need to look into whether or not there's a safe means of egress. So these are the initial things you should start thinking about when evaluating a fire accident and fire injury claim, whether on the plaintiff or defense side. What caused it? Who are the potential tortfeasors? Were there smoke alarms? Were they working? Were they installed? Were they properly placed? Were there carbon monoxide detectors? Was there a safe means of egress? These are all the initial factors that you want to start to consider. All right. I'll keep going, Michelle, probably for about another 5 minutes, and then I'll let you jump in. Okay. All right. So who has the duty here? Who has the responsibility? Who are the potential defendants or tortfeasors? Well, that's where things get really interesting. This is all defined by statutes in every jurisdiction, as far as I know, and the common law, case law looks at these statutes. But at least here in New York, there are very, very specific laws. And I've given you a bounty of information in your materials. As you know, I don't like to share my screen unless I really think it's important. I'm not going to today, but look at the materials after this, or if you want to scroll through, if you're sick of looking at me, feel free to do so. But in the materials, I've given you all the case statutes that apply in New York City, New York State. There's a link Michelle just put in to download the materials. If you're listening on the podcast, there's a link in the description to download all the materials. And I've done a good job, I believe, from my cases of really digging through these New York State, New York City, and federal laws. And that's really what you're going to want to comb through. And that's why I gave them to you, because they will dictate who's responsible for what. But I'm going to give you the general overview, okay? Generally speaking, the owner the owner of a building. If it's apartment building, think of New York City, all these residential apartment buildings. Think of multifamily dwellings that rent out homes. The owner is going to have certain duties under the law. And in New York State and in New York City, that owner is going to have a duty to install smoke alarms. They're going to have a duty to install carbon monoxide detectors. They're going to have a duty to make sure that when they're installed, they're in good operating condition and active and activated. They're going to have an obligation and a duty to make sure they're properly placed. There's specifications of where to place these detectors. And they're going to have the duty to make sure when tenants move in and out to check on these and make sure that they're up to code and to date. So there's a lot of duties on the owner. And that's generally what you're going to be focused on if you're representing the tenants, who are usually the ones who are injured or pass away. You're going to look at what the owner's obligations were, and did they fail to meet those? Was that the negligence that gives you the basis for a claim? Now, the tenant does have some duties, and that is usually where most of us get scared off. The tenant's job under the law, once they're in the unit, okay, in the apartment, to make sure the battery's checked every once in a while, make sure they're on, make sure they're working, notify the owner if there's any problems, if they need to replace it. They're not supposed to take them down and deactivate them. So the tenant does have some obligations, okay? But do not let that scare you away from taking a case. Do not let, if a tenant who gets injured was the undisputed cause of the fire, do not let that scare you away from taking the case, because these are still viable claims, okay? And I'm going to give you a fact pattern that we're going to talk about right now throughout the case, and it's the same fact pattern in the case I litigated that's throughout your materials.
If you're joining us today via podcast, the first attendance verification code is POD 501. That's POD 501.
All right, so here's the fact pattern. This is an actual case that I litigated and is the basis of all the materials that I've provided that we'll talk about in the packet that you've received. All right, so I represented Stanley Williams, the Williams case. Now, Stanley was living with his sister, Rena Williams. And Stanley and Rena, brother and sister, were living together in a two-bedroom apartment in Co-op City. For those of you not familiar with Co-op City, it's a development, kind of like its own city within a city, of multiple high-rise apartment buildings. And it is generally lower income people. It is supported by the state of New York, and it's been around for a long time. So they are up on the 14th floor in their apartment, and Stanley's asleep, and Rena gets up really early in the morning, and she's a smoker, and she has a cigarette in the living room. She puts it out in the ashtray, and or she may have had a couple cigarettes, but when she's done, they're in the ashtray, and she has a bag next to the couch that she dumps the ashes in. And you can see where this is going. She then goes back to sleep. So Rena and Stanley are both in their rooms in the apartment, and in the living room, the ashes were not out, and the garbage bag catches on fire. The sofa catches on fire, and it spreads. And next thing you know, the apartment is raging in a fire. It blows out one of the windows. Smoke is seen from the outside, and people in the building start smelling smoke, and people outside of the building see smoke and start calling 911 for the fire department to come and respond. Meanwhile, inside the house, Stanley and Ren are sleeping, and this fire is starting to rage. By the time the smoke gets significant enough from the flames and the fire that it reaches into their rooms, they're awoken by the smoke. They get up, they try and get to the front door to get out, but they're unsuccessful, and they pass out by the front door from the carbon monoxide of the fire before they're able to escape. The first responders, the fire department, they went up, they used the battering ram, opened up the door, and it was filled with smoke. They're crawling around on the floor in all their protective gear, and they touch and they find Stanley and Rena on the floor, passed out. They drag them out and get them off to the hospital. And Rena is in the burn unit for about 1 to 2 months, and then she passes away. Stanley sustained burns all over his body, his head, his face, his arms, his back, everywhere, and suffered a brain injury, and he survived. So that's the fact pattern. And Stanley, because of his brain injury, inability to recall, he had no memory of the fire, very badly injured physically, mentally. He had his sister, an attorney, and actually now a law professor, assigned and appointed as his guardian for everything. So the guardian, her name is Sarah Williams. She reached out to me. And interestingly, she told me that she had consulted with another law firm. And when the law firm heard that the fire happened as a result of Rena, one of the tenants, causing it, and that any claim of smoke detectors not working would be the obligation of the tenant under the New York City Administrative Code, they just didn't see where we'd be going with this case, and they turned it down. So we took the case on, and due to a potential conflict between the brother and the sister, because we know the sister caused the fire and would therefore be deemed a tortfeasor, I contacted a fellow plaintiff's firm that I know and asked them if they would work on the case, and they would represent the estate who passed away, Rena, her estate, being handled by her son, Stanley's nephew, and I would handle Stanley's case, and I would take the lead on it. And that's the fact pattern. All right. So thinking about it, many people might say this is not a case because the tenant caused it. What happened? How can you hold the building owner responsible? And this is not, unfortunately, an uncommon type of fact pattern where someone in an apartment building falls asleep with a candle burning or cigarettes, and the apartment goes up in flames. And the question is then, well, is it a case? Well, the way you find out is by doing an investigation. So let's walk through the investigation that we did in this case and the investigation that should be done in these types of cases. And let's talk about the statutes that apply and what you look for in your investigation. So I mentioned a little bit earlier that New York has statutes. In New York City, for those practitioners that handle a lot of cases in New York City, there's something called the New York City Administrative Code. And it can be extremely confusing and puzzling. Many of us lawyers practicing in New York City will have heard of the Administrative Code, the Multiple Dwelling Law, the Building Code, the New York City Housing Maintenance Code. Where do you look? Which one applies? Well, I'm no expert on municipal law, but I can tell you that they're all interrelated, and they're usually a branch of the New York City Administrative Code, which is up there, and then the building code, the housing codes, all these fall within it. And one of the big challenges is to sort all these out and find out what applies. And that's where hopefully I've helped you in the materials, where I've included some actual printouts of the actual administrative code statutes. I also saved sort of a cheat sheet of mine that I pulled in all different codes that apply. I also pulled in a federal statute, which is known as the Federal National Fire Protection Association. And it's also the National Fire Alarm and Signaling Code. And parts of ANSI, ANSI apply to that. And that's in your materials. That's sort of a general overview that applies throughout the country of where smoke detectors should be placed and why and how many you should have. And so you're going to want to look at your fact pattern. You're going to want to look at these statutes, and you're going to want to see, maybe is there something here? And that's what we did. And we knew to do that in this fact pattern because we've had previous cases involving fires and tenants. And we weren't satisfied with the general assumption that, oh, well, if it's a claim of a lack of a smoke detector, that's up to the tenant under the administrative code. But people and lawyers generally don't dig deeper. But you can see that that is true under certain circumstances, but the proper equipment has to be there in the first place. It has to be installed in the proper places. It has to be up to date, up to code. And that is all on the obligation of the owner under these statutes. The owner also, if they take on the duty to do regular maintenance or regular inspection, that's another hook to get in. Most of these big buildings will have, as part of their own insurance or as part of their own mortgage, a requirement regarding smoke detectors, carbon monoxide, because insurance companies and mortgage holders of apartment buildings and homes that have apartments in them, they don't want to be sued. They don't want to be sued because there was a fire causing injury. They want to make sure that the proper devices are in there. So oftentimes what you'll see, especially in larger structures, larger buildings, and we certainly saw it in this Co-op City complex, but also in other cases, New York City Housing Authority is an example. Most apartment buildings in New York will have internal requirements that whenever a maintenance person enters an apartment, on the checklist, there's a checklist. Did you check the smoke detectors? Did you check their expiration dates? Did you check to make sure that they're working? Did you hit the test button? Okay. So you're going to want to see, did they do that? Because if they didn't do it, and you find out that the smoke detector expired, that's a basis for liability on them. If they did do it, but did it negligently, and they claim they checked it, but it turns out when you get that smoke detector, it had expired 10 years ago, and they wrongfully put in their checklist, oh, it's up to date, because they don't really care and they're just checking it off, or they don't check at all and they're supposed to. These all provide additional basis for liability. Many of you know that if an entity takes on duty, then they're obligated to continue and do it properly. So you're going to want to find out a lot of information based on these statutes. We always look at who installed, were they proper, were they properly placed, what happened here? And then you start to build your case. You start to do your investigation. You keep looking at the laws. Okay. You'll see that in New York City, smoke alarms are supposed to be placed outside of each bedroom. There's requirements of how high off the ground, how low from the ceiling. Same thing with carbon monoxide detectors. There are listed requirements in the statutes that I've provided in these materials that show how far from the front door they're supposed to be placed, when they're supposed to be placed, how many they're supposed to be. So depending on the size of the apartment, depending on how many bedrooms, it could be that it's a 3-bedroom unit, but they only put 2 smoke alarms in. They didn't put a carbon monoxide detector in, and they didn't put one over one of the bedrooms. And if you can argue that that would have made a difference based on location, that would have given them warning to get out in time, then you have a claim, you have a case. And these cases will usually resolve if the injuries are as significant as they usually are. So you need to see if you have a legal basis. So it's getting those initial facts, knowing that you want to look into cause and origin, smoke detectors, placement, operation, carbon monoxide detectors, means of egress, and then applying it to those statutes, and then you go from there. So the investigation is the next part, and that's super, super important, all right? So what you want to do, first of all, is you want to check and see what the responding fire department did. The good news in these cases is that there's usually an investigation done for you. The question is whether it was robust or not, and what information you can glean from that. In New York City, the way that it works is when the FDNY, the New York City Fire Department, when they respond to a fire like they did in Stanley's fire, they will have very detailed information recorded. They will have a fire incident report, which will give information about when the calls came in, who called it in, 911, the witnesses, information, the first responders, what they found. There'll be timelines of which units respond. You'll learn that there's some ladder units. Their job is with the big ladders to go up. There's some units that have all the hoses that are there to put it out. And these fire incident reports will give you a blow by blow, time by time, literally time stamped, which unit shows up when, from what location, what ladder company, what fire company. You'll see what they did, who they spoke with. So in the materials, when you look at them, you'll see we requested the incident report for the accident involving Stanley and Renna. And we got a pretty robust multi-page report. And the way you get that is from a FOIL request, Freedom of Information Law. And just a little practical tip, the fastest way in New York City to get it, and perhaps in other jurisdictions around the country, find out where the headquarters are for that department, and you can go there and fill out a form, and they'll usually give you the incident report right away. In New York City, that location is One Metrotech down in Brooklyn. So you can actually go there, go up to one of the service windows and make your request. That's a way to expedite it. But I've given you in the materials a sample FOIL letter that you can use to request an incident report and the incident report in Stanley Williams and Renna Williams accident case. And then when you get that report, that's the key first thing. You need to find out what happened. Now, aside from a family member calling you up saying, yeah, our family member is in the hospital, there was a fire, they're probably not going to know more. So you really want to push hard. If you work with experts, which I always suggest you get on early, you're going to want to get a cause and origin fire expert, which exists. And the Academy has lots of sponsors who can help you get experts. Get them involved early. Sometimes they have connections. Sometimes they can get you perhaps a draft of one of the incident reports or a fire marshal's report, but that will give you an idea of what's going on. And you'll see in the materials, the incident report in Stanley and Renna's case, when you look through it, it gives a lot of information, all right? It gives a lot of information about what happened. And it also shows whether or not there were operative smoke detectors. There's usually a section in incident reports, and it'll be like a yes, no. Fire, smoke alarms present, yes, no. Smoke alarms operating, yes, no. Things like that. Carbon monoxide present, yes, no. Functioning, yes, no. So sometimes they will indicate in there whether there was a smoke alarm, whether there wasn't. Same with carbon monoxide. Sometimes they'll indicate they found a smoke alarm, but it wasn't functioning. In addition to the incident report, you're going to want to request the fire marshal's report. So the fire marshal, at least as far as I know in New York City and New York State, and I would imagine it's similar in other jurisdictions, the fire marshal serves an investigative duty. They come in after the fire is put out. So in Stanley and Renna's fire incident, first, all the trucks come, the ladder companies, the suppression, the hoses, they all come in. They go to fight the fire and rescue Stanley and Renna. And these people are amazing. I mean, they're true heroes. I have the deposition in the materials from the fire marshal. I didn't want to overwhelm you, but I also took the deposition of the captain of the fire unit that actually went in and broke down the door. And it was like a movie. I was sitting there asking these questions. What happened next? And then what happened? And he's telling me how he and his team go in with full oxygen masks, headgear, like scuba gear. They've got tanks on their back. They've got all kinds of tools. And they go in and he's telling me how he knocked down the door and he's hit with a wall of black smoke. He can't see anything. And they're trained to get down on the floor and lie down and start crawling and reaching out. And he touched the people, Stanley and Renna, and he grabs them and he rescues them and pulls them out. And they pass them off. I mean, it's like something out of a movie. I mean, true heroes, what they're doing here. And they saved Stanley's life, and they were close to saving Renna's life. So their job is to get in, rescue people, and put out the fire. Once that's done, and the fire's out, and people are rescued, that's when the fire marshal comes in. And then the fire marshal comes in and does the inspection and looks for cause and origin and looks for smoke detectors, smoke alarms, means of egress. So you're going to want to request the fire marshal's report. Now, these can take some time, and it's very frustrating for us. So all I recommend you do is keep contacting the fire departments that you're reaching out to. ask experts to help you, investigative firms to help you, whatever you can do to try and get these. But they're going to give you a ton of information. And when we did this in our case, the reports that we received and the incident reports in your materials indicated that there were fire alarms observed, but not functioning. We didn't know what that meant. What does that mean? Does it mean their battery and there was no battery in it? Are they hardwired? What's going on? We needed to learn more. So one of the things you're going to need to do, and I recommend anyone does handling a fire accident case, and whether smoke alarms or carbon monoxide alarms are an issue, not only do you need to read all these statutes and find out what's required as far as what to put in, how many, and where to place it, but you should learn about the different alarms that are out there because it makes a difference. And I'm going to give you a little primer right now because this is what I learned from handling these cases. One of the things that I like about doing plaintiff's personal injury work is this investigative part. It's figuring stuff out. It's learning new things. And when I started handling these cases decades ago, it was fascinating. And then technology changes and you got to learn more. So what I learned was that the smoke alarms in this case were manufactured by a company called Kidde, Kidde. There aren't that many names out there, and Kidde was the smoke alarm involved. Once I was able to determine which model or what type, I went on Amazon and I ordered like 10 of them. And I kept ordering them. And I read the manuals and I looked at the alarm and I looked at how it worked and how it mounted. And I took it apart and saw what kind of battery and whether you need to activate it and how you test it so that I had an understanding of what was going on here. And I encourage people to do that. It's a great way to learn and become a better advocate when you're looking into these cases. But generally speaking, at least of within the last year, smoke alarms are usually battery powered or hardwired. And it makes sense, but I'll explain what it means. Battery operated is there's a battery inside the unit. It comes with a mounting bracket. You mount the bracket up onto the wall. You pop on the smoke detector. You lock it in. If it needs to be activated, we'll talk about it. You activate it. You press the test button, make sure it's working, and you're good to go. Hardwired is when there's an electrical system within the building, and many large buildings will do this, and they tap off of that and they actually run a wire into the alarm and it runs off electricity. So you don't have to worry about a battery failing or dying, and those are hardwired. So you're going to want to find out, is it battery or hardwired? Now with the batteries, there's two types. There's the kind that you pop in, like the 9-volt battery. Those are the old school ones where it's like the two prongs on top. They're kind of a rectangle. You put it in, you connect it, you close it. And those can be replaced, removed by the tenant. Then there are the ones that are most prominent now, which are the lithium batteries, which are built into the smoke detector, which cannot be removed by a user or a tenant. They do not get replaced, and they usually have a 7 to 10 year life expectancy. Those are the ones generally that are on the market now. These are the lithium batteries. And there's pros and cons to them. Mostly pros are that you don't have to worry about changing a battery, and you don't have to worry about a tenant removing a battery, because unless they go out of their way to do what I did and unscrew the 5 or 6 little screws around, pull off the backing, remove some wires, open it up, and figure out how to disable the lithium battery that's in there, put it all back together and put it up for some reason. I don't know anyone who would do that. No one's removing it. Okay. So as far as a building owner, you're going to want to make sure you use either hardwired or lithium, because there's not a chance a tenant can mess with it. And if you're representing a tenant, it will help you, because you can say, listen, they couldn't mess with it. If it's put in and activated properly, it's got to work. There's nothing my tenant could have done, my client could have done it's not their job to replace batteries. It's supposed to last for 10 years, and you put it in Did you tell them it expires in 10 years? No, because it's your obligation to check it and make sure after 10 years you replace them. That's the owner's obligation. So you're really going to want to learn about the smoke detectors, the smoke alarms, the carbon monoxide detectors, because that's going to help you in your investigation if the defense wants to say, oh, if it wasn't on, it's probably because your client or your client's roommate removed the battery, right? And you'll be able to say, well, I looked into it and you can't remove the battery on these. So what are you saying? You need to do this and you need to look into this. All right. So I've got a lot more to go in a little bit of time. I quickly looked, I saw some good questions. I will address all questions, which I encourage between 2 and 2:30. So let me try and quickly get through in the last 15 minutes the highlights. And again, always reach out to me to talk further if you've got a case now or in the future that you want to discuss for any reason. You can scan this QR code next to me and that'll give you the link to have a complimentary Zoom or email me. All right. So what we did then in Stanley and Rena's case is after we got these fire incident reports and fire marshal reports, we did non-party depositions of the fire marshal and the captain, who I told you about, who went in first, to get as much information as we could. And we noticed these and conducted these before doing any other depositions or discovery, which you can do once you commence an action. So we did non-party depositions, and I went through, found out that photos were taken by the fire department. Those were in the FOIL response. So I went through the photos. I went through the reports with the Fire Marshal Jacob Gershon, and his deposition transcript is in your materials, so that you can use that to give you an idea of what to look for and what questions to ask. You can match it up with the incident report as well. So if you want to look into that, that's in the materials. And we ask questions. Well, what did you see? And what did you do? And you said it wasn't functional. What did you mean by that? He says, oh, well, I don't remember exactly, but my normal practice is I take it off and look at it. If it's a built-in battery, I'll hit the test button and see if it goes off. And I recall in this one, I hit the test button and nothing happened. And I said, well, in your investigation, did you ask any of these witnesses whether they heard any fire alarms going off? Because as we all probably know, when at home, if your smoke alarm goes off purposely or by accident, I mean, it is piercing. My fellow lawyers in my firm weren't too happy when I kept testing the smoke alarms and all of a sudden this like loud siren was going off, but it's this high-pitched piercing sound. So if you're in a building, neighbors are going to hear it. And so we wanted to find out, did they sleep through the smoke alarm? What's the deal? And we found out from all the witnesses, no, nobody heard anything going off. And we found out that there were only 2 smoke alarms in there. And it was a 2-bedroom apartment. There was no carbon monoxide detector. So we wanted to look into whether it was required or not. We looked into whether the smoke alarms were properly placed. We found out that the smoke alarm outside of Rena's room was taken off the wall and it was sitting on her bookshelf. We found out that the other smoke alarm outside of Stanley's was in place outside of his bedroom door, which is where they're supposed to be, but it didn't sound. So what we immediately did is we got our own expert. We requested immediate access to the apartment. They will generally preserve the apartment. I know there was a question in there about, what if they, condemn it or destroy an apartment or a building as a result of the fire before you can get in. That's why if you get in early, if you're retained early, you have to start sending preservation letters. You have to start working the phones, finding out the management company, sending letters that nobody should enter there without our approval, really try and lock it down. And in Stanley and Rena's situation, through Co-op City, they basically kept it boarded up. After the fire marshal left, they had their own fire expert, go in, take the detectors down, put them in an evidence bag, and didn't do it quite well. So that gave me room for fodder. We were in federal court, so I was able to really show a lack of chain of custody, which is an issue as well. But you want to get in there as soon as you can with your expert. Let them take photos. Let them see what they can find. You want to make sure those smoke detectors, if there were any there, are preserved. Send preservation letters all over the place. Preserve the detectors, preserve everything, preserve the scene, so that ultimately you can see them. And ultimately, in their case, we got the detectors. They were preserved. We agreed to have an inspection where we can look at them without touching them and photograph them. This way, we were able to get more information and do more research. Ultimately, all the parties agreed to hire a lab that tests smoke detectors. They actually can x-ray them. So this way you're not destroying it, and they can look through, they can test it to see if the battery was active, whether it was working, whether it was just a defective unit. And our argument, and I'm running out of time fast here, but ultimately our argument was as follows. First of all, that they should have had a carbon monoxide detector, and they didn't. And if they did, that would have given them notice. They could have gotten out in time. Secondly, that they either put in defective or unactivated smoke alarms. So on these lithium ones, when you buy them from wherever, they're not on, they're not activated. So you have to mount them properly. And if you mount them, if you put the bracket up and you put the unit in, when you turn it, it's going to move a lever and it's going to click. And that's what's going to activate it. Then you test the button, you hear it working, then you know it's on. Our position was that, at least for one of them, based on the position we saw of the levers, it was never activated. That they probably went in, put them all up, clicked it in, and maybe it didn't click in all the way. They didn't press the button. And our theory was they didn't activate it. And we tested one out and the battery was dead. And we were like, how did the battery die? Was it defective to begin with? Who tested it? We found out they had inspection records requiring them to test it. We found out with Co-op City that because they got this huge multi-$100 million mortgage, that part of that mortgage required all new detectors, testing of them, certain types. And we found out that the money that was allotted for it wasn't all spent as indicated. It looked like they didn't put as many smoke detectors in as they were supposed to in each unit. It looked like they may not have activated it. And this is the path we went down. And that's how we were making out a case. Now, as far as if you're wondering, well, what about Rena? She's the one who lit the cigarette. How does she have a case? Well, again, she has a case. There may be some contrib on her part, but it's known that people can cause their own fires. That's usually, if it's not an electrical fire, that's usually how these fires start. And that's why you have these smoke detectors. And our experts were going to say that even if she did light it, if they put in properly working smoke detectors, she would have been out of there and notified of it well in time. So these are cases. And so the law firm that turned down this case because of that missed out on an opportunity to help a family get recovery. And we brought the case in federal court. We made the claims that I've told you. Also, they tried to say that, oh, well, the smoke detector in Rena's bedroom was taken off the wall. She must have deactivated it because she's a smoker. We said, well, if she took it off, why was it resting on the bookcase? We don't know because she passed away. Nobody knows the answer. We never would know. However, we determined that you can't just deactivate it. And when we looked at it, it wasn't activated. So the way that the lever works, it has these little click-ins that, like when you ratchet and you get past each click, it can't go back. And so you can't deactivate it. So our argument was whether it's sitting on a bookcase or up on the wall, if it was properly activated, it should have worked, but that they didn't properly activate it. And then we were taking depositions of the people whose job it was to activate it. And then we found out one of them was in prison, and it turns out he lied at his deposition in our case. And so once you get underway, a lot of these things come up that can help or hurt a case. And we got some good stuff. We brought it in federal court based on diversity. We had a choice. This was in the Bronx. Do we bring this case in state Supreme Court in the Bronx? Or can we bring it in federal court by diversity jurisdiction? Because Sarah, as guardian of Stanley, lived in Pennsylvania. And we were able to establish that based on she was the plaintiff. And we had the right to bring it in federal court. And we tested that out. Lawrence Kaplan, many of you know of, a prominent federal judge, actually had a conference with us. He wanted to make sure that he had subject matter jurisdiction and that we truly were able to bring it based on that. And we all confirmed we were. And we decided, while the Bronx may be better venue for jurors, that if we brought this kid in the Bronx, we'd be dragged out for multiple years in litigation. And by bringing it in federal court, things move quickly. It's more expensive. I've lectured on this. You can find a separate lecture on the pros and cons of federal court. But all their attempts, the defendants, to delay didn't work because we had a federal judge keeping things moving. And we disclosed all of our expert exchanges. We had a plastic surgeon, we had fire experts, we had life care planners, and we were able to resolve the case for a substantial sum for both Stanley, who was injured, and for Rena's estate. They were both seven-figure results as a result of the case, because we were able to prove, we felt strongly, negligence. So I have the summons and complaint in here. It's a federal one in their case, so feel free to use that. I also, in discovery, which I could do a whole nother lecture on, there's a lot of things you're going to want to ask for. Installation records, the identity of when it was installed, what types of detectors were installed. Many statutes and laws require record keeping. You'll see that in what I've put in the materials. You ask for all those records. So we're in federal court, so we served them with interrogatories, and we served with a request for production of documents. So you can use these and just turn them to state. It would be a notice for discovery and inspection as opposed to the federal pleadings. But all the things that you want to ask for are in there. So that's in your materials as well. I think that will be helpful to you. And that'll help get you going. And then once you're underway and you get these records and you start doing these depositions, the case will become clearer. And if you work it up right with the proper damages experts, which I've talked about in another CLE you can find on the Mentor ESQ website or the Academy's website, working with expert, build up your damages case, work on that, and then you will be able to successfully litigate these cases. Now, who did we name briefly? You'll see we named the building owner. We named Douglas Elliman Property Management, because it is going to be the property manager who's going to be running the show here. So for all these buildings, you're bringing in the owner and the property manager and the managing agent, because they're the ones that are going to have their crew out there doing the installations, requisitioning the alarms, doing the orders. You're going to want to get all the invoices. You're going to get all the installation information. You're going to want to find out if they gave the packet, the inserts, to the tenants, saying what they're supposed to do, and check. How can you blame a tenant for not maintaining their detector if you don't even give them the materials to do so? And they usually don't. So there's lots of ways to go here. Hopefully, I've been able to give you a good enough overview of these types of cases so that you feel comfortable in getting involved with them. We are wrapping it up in a few minutes here, so I will begin with the Q&A. And again, if there's something I don't touch base on, just reach out to me. I'm always happy to meet with you. If we haven't met yet, I'd love to do a one-on-one with you. It's complimentary Zoom for 30 minutes. All right, so Maxim is asking whether these fire cases are always 100% contingency cases, with all costs and disbursements being the obligation of the attorney. So that's two questions in one. Generally, they are. And what we do in personal injury law, generally it's a contingency fee. I don't think anybody would hire somebody hourly to work on this, or anybody would take this on hourly, or people could frankly afford to pay hourly for the amount of work that goes into these cases. So yes, they generally are 100% contingency fee cases. And as far as costs and disbursements, in New York State, in retainer agreements on contingency cases, you're required to give the client the option one or option two, of whether they would like to pay for the expenses or whether they would like you to pay for the expenses. We always recommend option two, where our firm absorbs the costs. I don't think anyone has ever chosen option one, where they pay the costs. Basically, and this is a different subject, but just to wrap this point up, if you, as the law firm, take on the costs, you get all of your costs back when the case resolves, and then your fee, your 1/3 fee, which is generally what it is in New York State, of the recovery. If they lay out the costs, then those costs are deducted from the total fee, and then you get your third. So usually it could work out a little bit better for the plaintiff if they pay for the costs. But I always advise lawyers and clients that the savings you'd make is not worth the nightmare and headache of spending. And especially, I mean, this case, the Stanley Williams case, I think the plastic surgeon fee alone was $25,000 to evaluate and write an incredible report and photograph and everything. He was a top plastic surgeon in New York City. So these cases get very expensive. So you have to have the wherewithal to properly fund them. If not, you're going to want to team up with a firm like mine or another firm that's used to investing in these types of cases. Okay, so Shane is asking, how do you handle causation investigations if New York City orders demolition of the property immediately after the fire? Again, that's usually nothing happens too fast in New York City or other municipalities. So usually they're not coming in with a wrecking ball or anything like that very quickly. And if you put the managing agent on notice that to preserve it, you're usually fine and can usually get in there. In fact, they dragged their heels, Co-op City, in Stanley and Rena's case, because they needed a place to live. Stanley needed a home. He was, displaced. And while he was an inpatient for a long time, they couldn't discharge him from a rehab facility because he didn't have a place to go. And we were trying to get him, let's go, people. You have to remedy the apartment under the lease. We had to bring in a real estate litigator to force the issue. It wasn't easy. But it was the opposite. They weren't quick to fix it or change it. Usually you have time, but that's the reason that you need to get those preservation letters out, and you can keep people at bay from messing with the apartment or destroying it in so doing. All right, Julie is talking about Co-op City being a cooperative in owning shares. That is correct. And as a technical matter, although there's a management company, there's no landlord. Do the statutes in New York applying to fires distinguish between apartments that are rental or condos or co-ops? So my reading of it is that no, it doesn't distinguish. Basically, it shows that the co-op still they're the managing agent of the co-op has the obligation if they're the ones who initially installed it. Now, so that's why in our case, we were able to go after the managing agents, all right, because they were the ones that undertook all of this and to comply with the HUD, the huge loan that they got, the owner and the managing agent had to take affirmative steps. Now, let's say it's a typical situation. I lived in Brooklyn in a 5-apartment co-op, right? It was like a brownstone type building broken up into units, and we were a co-op. Now, if we as a co-op all agreed in the bylaws that it was up to ourselves, that we had to, put in these smoke detectors and maintain them, and it was up to each individual owner, then we wouldn't be able to sue the co-op at large, right? So you're going to want to look into that if that's the situation. But generally, large buildings, whether it's a rental, co-op, or condo, is usually going to have a managing agent, and you're going to want to dig deep and find out what the obligations were. Again, if it is a co-op or a condo, no matter what size, that affirmatively puts the onus on those individual owners of the co-op or condo, and they've done nothing from a managing agent perspective with regard to smoke alarms, then you may be out of luck. But again, once they undertake that, they have to do it non-negligently. Hopefully that answers your question, Julie. Okay. Bill, how you doing, my friend? Giving an FYI of what goes on outside of New York City, and that the fire chief is generally required to determine the cause by law. So that's something to look at in other jurisdictions. Again, always want to do your homework and find out who's responsible for what investigation. Sometimes you get a really thorough, great investigation by the investigating agency, whether it's the fire chief, fire marshal, or some other entity, depending on your jurisdiction. Sometimes you don't. All the more reason, find an expert, do a preservation, send letters saying, we've been retained by this family. We want to get in with our expert. You need to provide access. And if need be, you file an order to show cause for to do an investigation and to get into the premises. And if it's a condo or a co-op, you shouldn't be kept out of it because your family or your client is the owner, and they should be able to give you access. So it can work in a lot of different ways. All right. Hey, Mitchell. Yes, please send my best to Pam, my law school classmate who I miss very much and happy to hear from. All right. Where are we now? Joseph. All right, Joseph, thank you. You're a volunteer firefighter, represent a small town fire department. Talking about how FOIL doesn't work too well since they don't do the paperwork, and they're not witnesses. Fire departments are low to identify, the responses. They just basically want to fight fires. So you're going to run into that a lot. Again, why you're going to need to get experts on board fast. And at the very least, get your investigators out there. Start questioning neighbors. Do your own FOIL requests. Find out who placed the 911 calls. Get out there. Start interviewing people, neighbors, apartment neighbors, building neighbors. What'd you see? What'd you hear? That kind of stuff. But the key is always going to be getting into that apartment with an expert. Get in there. And if you can get in fast and you don't have an expert, get in, photograph everything, make sure everything's preserved properly. Don't mess with any evidence unless you videotape it. We always make sure that if we're going to be removing smoke detectors or anything, that we have a qualified expert do it, not us. Because as a plaintiff's lawyer, you don't want to be a witness. You want to be able to call your expert to the stand and talk about the chain of custody. You're going to want to videotape them removing it, putting it into a bag, sealing it with tape, initialing it across the seal. These are ways that you preserve evidence properly, and you need to make sure that's done. Because if the chain of command is messed with, or if someone messes with those detectors before you and your experts have a chance to examine them, it may ruin your case. You may not be able to prove that something was wrong. They could get in there and mess with it before you have a chance to look at it. Okay. All right, Bernadette. You can also bring a motion pre-action for discovery. You did that in the 91st Street crane collapse. How you doing, Bernadette? Yeah, and great work on that for the whole plaintiff's bar on your case, and making great law on pain and suffering, conscious pain and suffering that we often use in my firm. Yeah, so pre-action discovery. Bernadette, maybe you can share the CPLR provision. I don't know it off the top of my head, but you are entitled in all cases, not just fire cases, to do pre-action discovery under certain circumstances to determine whether or not you have a viable case. Sometimes the courts don't grant it and they say file your suit and you can get it in normal discovery, but we've successfully made those pre-action motions to get information, to get onto the premises. So that's a great suggestion, Bernadette. Thank you. All right, James, does the amount of available liability insurance affect your decision on taking a case with good liability and severe injury? Great question, and of course it does. Of course it does. So you could have a fire case in a private home that is a 3-family home, and it happens in one of the apartments they were renting out, and it turns out they really didn't have any homeowners coverage or very minimal. Then you've got to decide if it's a death case under the current states in New York, where the Wrongful Death Act limits damage recovery, unfortunately, despite all of the bar and the Academy's efforts to change the law, which our governor has not signed off on yet. The damages can be limited. If someone dies immediately in a fire, you can't prove conscious pain and suffering. And if they die and they don't have a will, and you have to get letters of administration, you're going to need a wrongful death compromise order, and you find out there's just not a lot of coverage, you may want to pass on the case, which is unfortunate, but that's part of what we do as plaintiffs lawyers. We have to make those decisions in all types of cases. In Stanley and Rena's case, Rena had a $300,000 homeowners coverage policy that we were able to go after on behalf of Stanley, and it was tendered right away. So we had to bring that in. So Stanley had to sue the estate of his deceased sister, which was run by his nephew. So obviously we talk about that with the family. We explain this is how it works. We explain that no matter what, Rena's estate was going to be sued by the defendant as a third party, and they were, that she caused the fire. So we wanted to make sure that that's why the firm that we asked to handle it could do the defense of that and the plaintiff's part for the estate, separate from my firm handling Stanley's case. And then we wanted to make sure, obviously, Co-op City had a big insurance policy. But yeah, you have to look into that. Coverage is always an issue. So you look into who the tortfeasors are and make sure that you bring them in if there's a significant amount of coverage to handle the damages in your case. Yes, Michelle.
Speaking of coverage issues, I don't know. I feel like we should do a whole series about different things and the coverage issues. What do you think?
I think that's a great idea, Michelle. And for those of you who may have seen the commercial ad that just ran, my partner Rosa Feeney is an insurance coverage specialist, and she is now handling for the whole plaintiff's bar and any conflicts for the defense bar coverage cases where there's disclaimers, there's disputes, there's denials, there's loss transfer issues. So Rosa and I are going to give a series of CLE presentations starting in the fall in October on coverage issues involving different cases. So we're hoping to do coverage issue involving construction cases, coverage issues involving auto cases is a separate one. So stay tuned for those in the fall. Thanks for throwing that out there, Michelle, to give everybody a preview. All right. So John, good question. What was Kidda's liability in this case, the smoke alarm company? So here's where you have to feel comfortable strategically as an attorney with who to bring in and whether to bring them in and make sure that your client is fully aware. So we had a decision to make. Do we bring the smoke alarm company in? Do we bring them in under a theory of product liability in addition to the building owner and the managing agent? And believe me, the lawyers for the building owner and managing agent wanted us to bring Kidda in and fight them to help pay up to defer some of the expense from the owner and managing agent. So what we did is we looked into it, and my firm handles product liability cases, and we had no way to prove that it was a defective product. And if it was defective, it would have been defective at the time of install. So if this came off the shelf defective and it didn't activate and it didn't fire up and the battery didn't work, that should have been determined when they installed it and hit the test button. That's the only chance of a defect happening would have been at the outset. So if it was defective, then they should have discovered it, in our opinion. And we didn't need to make that case for them. And we felt that as a plaintiff's firm doing products litigation, that we'd be much better situated to bring a products case if it was one. But if we didn't have a good faith basis to bring it, why would we do that? Legally, you're not supposed to. And practically, why would we, a product liability case is very costly, very difficult. And it turns out that the defendants third-partied in the smoke detector company, Kidda. And they kind of had to, I think that's checking the boxes for defense firms and loss transfer, say, well, maybe it was defective. We better bring them in. But most defense firms aren't adept or equipped to prosecute a product liability case. We're in federal court. We knew they were going to be under the gun with expert disclosures and being able to prove a case, facing summary judgment. And we knew that Kidda was going to fight this like crazy. I mean, this is their product that they have thousands of out there. And so we made the decision to initially not file suit under the product liability claim against them. We discussed it at length with our client, Sarah, who is a lawyer, now law professor, and we explained our reasoning and said, we don't want to file it, but you need to understand that we'll keep an eye on the statute, but as we get closer, you're going to have to explain to you why not, and we're going to need you to sign off on it to cover us from any legal. So we explained it to her. By that time, they were third-partied in. I became very friendly, I won't name names, with the partner from a very well-known, very good defense firm representing Kidda. And he was pushing back, and we basically were teammates. We were both pointing the finger at the defendants. We were saying, we have no reason to believe there's anything wrong with the product. You didn't activate it. You didn't install properly. There's so many things you did wrong. So we, at every deposition of every witness, the two of us, me and Kidda's counsel, were beating up on the defendant's witnesses and hitting them with motions and discovery demands and everything. And we sort of had an understanding. I was like, listen, we're not going after you. We don't see a viable case. And he's like, all right, great. So they didn't have any liability. And ultimately at the mediation, they didn't pay a dime. They did not pay a dime. It all came from the owners. So I give credit. It was very good defense work. They stuck by their guns, and they were smart also. They talked with me. We had an understanding that we're not going after each other. They're not going to point their guns blazing at our client sister for the cause, and we weren't going to bring them in. We were both felt comfortable with our positions. So be careful who you go after. And unless you specialize in handling products cases, and even if you do, you tread water carefully. And if you don't, you definitely don't want to just name a starter products case if you don't know what you're doing and you don't have a good faith basis and an expert to tell you that they believe the product was defective. Okay. All right. Thank you for the nice comments, Robert. All right, let's keep going. All right, H. Kim is asking, could I please speak to the co-op apartment fires where causation is unknown? Possible electrical issue inside a co-op building's walls or under the floor. So the way that I would approach that is if you don't know the cause and origin, but you do know there was a fire, and you can pretty much rule out that the tenant or the injured party caused it. No candles, no smoke alarms. No one knows. They woke up to the place in flames, and there's no determination of cause and origin. Then I would really focus on the detectors. Who put them in? Whose obligation? Were they working? Because ultimately, cause and origin doesn't really matter in these cases. And I find that when I litigate these cases, the defense firms improperly focus on who was the cause. I mean, they kept arguing to me throughout the case, yeah, but his own sister caused it, and he was there, and they took there was a smoke alarm taken off. And so they were really focusing on cause, but ultimately, in my opinion, cause doesn't matter if the proper devices that are required are there and working, because these things give notice super early. I mean, really, they will start to get when a little heat starts to get generated, a little smoke gets going. I mean, they will sense it. They'll sense the carbon monoxide, they'll sense the heat, then they'll sense smoke. There's usually smoke before there's fire. There's a reason there's that expression. So the smoke usually sets it off, and the fire and the CO before the apartment's engulfed. So don't get thrown off if you're not sure of the cause and origin. It's really good to find out, because that's another theory of liability. We've had cases where it was an electrical fire and there were some complaints of short circuits, complained to the managing agent. Someone saw a spark. They came and they fixed the receptacle, but maybe they didn't check the wiring. Then you get them on causing the fire. It's a stronger case, but you don't necessarily need that. So I hope that answered your question.
If you're joining us via podcast, the second attendance verification code is POD 245. Again, that's POD 245.
Mitch, have I considered a products liability case against the manufacturer of a smoke detector? So no, I've yet to do it. The reason is that generally they're either going to turn on or not. And if they turn on, they're going to work. The technology is not super difficult. And if they don't turn on, if they are defective, it's usually because they come off of the manufacturing line defective. The battery's not working. It's not activating. Maybe the test alarm or test button, or maybe the siren's not working. They have these little sirens in there. Maybe it's a defective siren. So the way that, that's not a case, in my opinion, is because whoever installs it, if it activates and if it sets and if it's armed, then it should work. And I am not aware of a situation where you can prove that it was properly installed, properly activated, properly tested, that it then didn't go off for some reason. I haven't seen that fact pattern. I guess if it is, and if you've preserved it, and if you can have your expert test it and look at it, then you would bring it. But it's going to be tough. These would be very tough cases, and they're going to fight them hard. I speak with a lot of lawyers running things by me, and so many times we said, yeah, but once you bring the lawsuit, they're not going to want to litigate it the whole way. They'll settle it, or they'll third party someone in. You'll get the case resolved. And too many lawyers start lawsuits hoping that will happen, and that usually does not happen. Usually you're going to get thrown out on summary judgment after you've spent a lot of time and money, and then you're going to have a very unhappy client. So unless you have the ability to really size up and determine there was a defect, either a design or manufacture, it's not going to be failure to warn, because they give instructions all the time. But again, that's a theory of negligence against the managing agent or the owner. If they're installing it, I mean, I asked in Stanley's case, all right, so you installed these, you say you tested it, you say you activated it and it worked fine. yet it's showing that it wasn't activated. Do you know how that could happen? Nah, I don't know. How many did you have to install that day? I don't know, hundreds. How long did it take you to install it in that apartment? I don't know. We're in there usually in 10 minutes. Oh, so in 10 minutes, you installed 3 smoke alarms. You tested them all and they all worked. Okay. So what did you do? I opened up this packet. Is this how it came to you? Yeah, we opened them up. It comes with the mounting. It's got the instruction booklet. Well, what'd you do with the instruction booklet? Oh, we throw those out. Otherwise, we have so many of them. Well, did you leave it with the tenant? No, I didn't leave it with the tenant. Did you give the tenant any verbal instructions? Did you tell them they need to test this every month or every year? Or tell them about anything that these instructions say are required for good testing and maintenance? Nah, I didn't tell them that. So that's another theory. So those are going to be much better theories, in my opinion, much easier, much more viable, much less expensive, much less difficult to litigate than a products case. All right. Sharmella, hi. You like that I didn't include them for the reasons that I stated, since you would be going on a wild goose chase and it's not ethical. I know that's a comment and not a question. Look, folks, just as a reminder that you should not be filing lawsuits unless you have a good faith basis that you have somewhere to go or that discovery may lead you somewhere. You really can't just start filing and naming companies just because they're deep pockets. We don't do that as a practice. And then if you do, because maybe in fairness, sometimes we bring lawsuits against a lot of entities because we're not sure which one controlled the situation. So I don't mind doing that. Like you'll see in our complaint, we listed Douglas Elliman Rental or Douglas Elliman Management. There were like 5 different types of Douglas Elliman companies that we found that may or may not have been the managing agent. So to protect your client and yourself, you name all of those, but that's in good faith based on the research we did, seeing all these different entities. And then once you get into it and defense counsel tells you, no, these 3 have nothing to do with it, they get you an affidavit, you work it out, you stip it out, and you let them out of the case. I mean, that I believe is the proper way to practice. Okay. David, what happens when the fire is intentionally started by the tenant and an injury or death occurs to another resident or guest? So that's a great question. I haven't had one of those cases, but here's my 2 cents. I think that if a fire is intentionally started for the purpose of a fire, not meaning they lit a candle on purpose, but meaning they purposely sparked up a couch or they're pyromaniac or they wanted to kill themselves and their neighbors or who knows what, then I think that is, of course, you're going to have a claim of an intentional tort, but you're probably going nowhere there. I think insurance could disclaim if it's an intentional act for that tortfeasor. But again, if I'm living in unit 14E and the person in 14F lights a fire on purpose to burn themselves and their family members alive, and I'm in the apartment next door, and I have smoke alarms that were not properly installed as per the statutes, and they don't go off, and they don't give me warning, and I get injured or die, then it's a case. Again, this goes back to me not being so concerned about cause and origin. You got to keep your eye on the ball here. The eye on the ball is focusing on the early detection and the early notice. That's what saves people. That's what saves them from injury. That's what saves them from death. That's what these cases are all about. So whether someone's lighting a fire on purpose, or it happens by accident, or it's your roommate, or it's even you negligently causing your own fire, the argument is, and it's backed by law and expert testimony, that regardless of how the fire was caused, if these smoke detectors were properly installed per code, if the CO detector or the combination detector, combination smoke alarm CO detector in one unit, if they're all properly installed, properly placed, the right amount, the right location, properly tested, activated, replaced when necessary, and they don't work and you can prove why, that's where you go. That's where you go. It doesn't matter what the start is of the case. Now, again, you're not going to get good coverage. Whereas if your neighbor was the one who lights the cigarette and falls asleep and they cause the fire, if they have a seven-figure homeowners policy, then that's an easier case. You don't have to prove anything about the smoke detectors. You just prove that they were negligent. The cause and origin shows that a cigarette caused it. And there you go. Their homeowners would cover it. That's as straightforward as they get. That would be a much easier case. So that goes back to looking into coverage. All right. Yolanda, thank you. Happy that you enjoyed the CLE. I think I covered all the answers with 4 minutes to go. So thank you all. It's always a pleasure. Programming note, the last one of this series, which is going to be a makeup because I was on trial for part 2. If anyone's wondering, and it seems like, did I miss part 2? What's going on? Part 2 on dram shop cases, which is when people get drunk and cause injury to third parties or death. Who's liable for that? We're going to talk about that on June 5th. I hope you all join me to learn on this last novel negligence case of the series.